Ms. Anthea Ong.
Mr. Speaker, I would like to express my support for this amendment. It reflects a deeper commitment to the protection and support for the vulnerable amongst us. We are also debating this bill at a time when a case of sexual voyeurism on university grounds has raised important and pressing questions about legal protection and institutional support for survivors. We must use the current focus on harassment to have a meaningful national conversation on how we can create a society that does not tolerate any form of harassment, one where bystanders feel equipped to intervene and survivors feel empowered to seek justice. Otherwise, these amendments will not fulfill their mission. One major change introduced is streamlining the process for applying and obtaining POHA orders in Section 17 of the bill. Currently, applicants need a lawyer to assist in the preparation and submission of documents and subsequent proceedings, and this can be financially prohibitive. It typically costs between $5,000 and $8,000, leading up to mediation, and significantly higher if mediation fails and the matter goes to court. I commend this amendment to make the process expeditious as well as more economical and accessible, which helps to make the ordeal less alienating and intimidating for the applicant. Lena is a survivor who did not submit her case to court because the process is currently complicated and costly. In her words, I quote, "I'm still struggling to rebuild my life. There was so much paperwork, and I would need to take leave to go down to the court so many times. It was too much for me." These changes will help individuals like Lena seek justice against their perpetrators. Though not provided for in the primary legislation, the Minister has assured us in his statements to the media that the subsidiary legislation will stipulate that an expedited protection order application under POHA could be granted within 48 to 72 hours. If there's actual violence or risk of violence, an expedited protection order could be granted within 24 hours. I think a $200 fee has also been cited. I seek the Minister's clarification on this. Mr. Speaker, at this juncture, I would like to highlight another obstacle that remains which may impede a survivor's access to help. Young adults under the age of 21 cannot seek protection orders under POHA unless a guardian makes applications on their behalf. This can be a deterrent from seeking legal redress for intimate partner violence and sexual harassment, even if social service agencies or law firms are involved. Tina, not her real name, was 20 when she approached Aware about a blackmail case. The perpetrator was threatening to leak explicit photos and videos of her if she did not continue to send him more. Despite the mental and emotional distress she was going through, she insisted on not involving her parents because she believed they would react badly. In fact, she preferred waiting a whole year to turn 21 so that she could go to the court alone. Tina's concerns are echoed by many, and they reflect a gap in the current system. Tina's story is not the only one I know. The 18-year-old student I was mentoring a few years ago was sexually harassed by her best friend's brother and did not seek protection either because she didn't want her parents to know, and they still don't know till today. I hope that barriers for 16 to 21-year-olds can be removed. If need be, we could appoint social workers or court counselors to support applications in place of the survivor's parents or guardian. We need to be cognizant of the social pressures that survivors might face and understand that some may not be ready to involve their family. The other significant change introduced in Section 8 of the bill is close to my heart, namely enhanced penalties for perpetrators for crimes against vulnerable persons. The bill defines these vulnerable persons as those with mental, physical disabilities, and victims in an intimate relationship with the perpetrator. These changes recognize that these persons are especially vulnerable to being targeted for harassment, potentially face greater psychological and physical damage from such harassment, and are less able to defend themselves or prevent such harassment. I've heard many bullying and harassment stories from just amongst my deaf friends and persons with mental health conditions whom I work with. This extra consideration and attention is definitely a progressive yet necessary step forward. But I cannot emphasize enough that the protection of the differently abled must not only come from the law. The continued harassment of these individuals originates from a deeper prejudice within our society. We must continue our whole-of-society efforts to tackle the root of this stigma and establish a widespread agreement to care and support the differently able. Mr. Speaker, I must at the same time urge caution when pursuing the strategy of enhanced punishments. There are valid concerns to be raised on the effectiveness of enhanced punishment in administering two key areas of justice, namely deterrence and retribution. Extensive studies reflect that enhanced punishment do not necessarily create a greater deterrent effect and may in fact be counterproductive. Research done by Center for Criminal Justice Studies in Canada has shown that longer sentences and harsher punishments do not reduce the rate of sexual crimes. Instead, the reverse may be observed, where longer sentences increase recidivism due to a lack of repentance for the initial crime, as reported by the National Research Council in the United States. Moreover, enhanced punishments may even counterproductively discourage the victim from reporting instances of harassment. In 8 out of the 10 cases that Aware Sexual Assault Care Centre sees, survivors know or are close to their perpetrators. In some cases, especially when the perpetrator is a family member, enhanced punishments may heighten the fears of destroying the perpetrator's life, deterring survivors from reporting. Jenny, for example, shared that even if the perpetrator, her father, was jailed for the maximum period of time, he would never feel the fear, shame, terror, and disgust that she's had to deal with throughout her childhood and into adulthood. She also shared that her mother would not be able to bear the guilt and it would devastate her. I quote, "So punishing him even for the longest time would only bring more pain," unquote. Harsh punishments are not necessarily an effective deterrent, nor do they serve survivors better. Instead, increasing victim support and making reporting and prosecution processes trauma-informed and more victim-friendly would go a long way in ensuring that survivors will come forward and sustain their involvement all the way to conviction. Improving the chances of securing convictions will do more to promote deterrence than imposing harsh penalties. In 2017, the UN Convention on the Elimination of All Forms of Discrimination Against Women Committee, or CEDAW, made a similar recommendation. CEDAW suggested that Singapore prioritizes gender sensitization training in the criminal justice system, not increasing punishment as a way to strengthen protection for women against gender-based violence. I also urge the government to consider and look into the deterrent effects of other measures like community service and restorative justice measures as restitutionary agreements. Mr. Speaker, I applaud the government for extending the recourse available under POHA to entities that are victims of harassment in Section 11. However, I would like to clarify if the protection that is now available to entities also creates an equal responsibility for them to exercise reasonable care to prevent and correct promptly any harassing behavior, failing which they would be held liable for their employees' actions. The sexual voyeurism case I mentioned at the start of my speech raises questions about organizational investigation processes, support offered to complainants, and helpful prevention programs. Although not legally enforceable, the Tripartite Advisory on Managing Workplace Harassment provides important guidelines on these issues, but it's unclear if the advisory covers institutes of higher learning. If they are not covered, I strongly urge the government to consider establishing a mandatory code on sexual and other forms of harassment that can hold institutes of higher learning accountable when they do not handle student complaints promptly and fairly. The changes made in this bill are driven by key principles that should be celebrated, especially in the clear commitment towards protecting and supporting the most vulnerable amongst us. Yet, Mr. Speaker, we must remember that legislative changes cannot be the end of the process of change. I hope that the ministry spares no effort in education and awareness efforts with schools, institutes of higher learning, workplaces, and communities so that every member of our society knows not just what their rights are, but also how to activate these rights in the face of bullying and harassment. Social support must be enhanced to ensure victims have an accessible and holistic process of recovery from these traumas. And more importantly, we must continue to spare no effort at every level to build a society with values of respect and inclusivity that will discourage these crimes against the vulnerable in the first place. Because a society that has more justice and compassion needs less charity. And our great hope in such a society is in individual character. Notwithstanding the above clarification, Mr. Speaker, I support this bill.